Alex here with part 24 of the My Docket series on child custody and visitation. As with my previous videos, I'll direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will glaze over, however, are number one, I'm not in the middle of this right now. My case is completely and totally closed. It's over. It cannot be reopened. My ex's parental rights have actually been terminated. Number two, the nutshell version as to the purpose of this series is to provide my viewers with one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. In part 23 of the My Docket series, we left off with my reply to one of my ex's oppositions. This video is more relevant to part 22, where we went over my ex's filing of a motion to strike my request for submission. This video specifically will go over my filing of my opposition to that motion. In other words, she is trying to strike a piece of paper that will send this briefing up to the court for consideration and a ruling, and I am opposing her efforts to strike that piece of paper. The basis for my ex's motion to strike is that she, number one, wasn't late, and that even if she was, number two, it was because of an oversight, what they call a excusable neglect. She was late because she tried to file it on time and the document was missing something that was, it was the affirmation. It was missing the affirmation, and so the clerks rejected it and she had to file it the next day, which was, it was late. So on one of those two bases, she's asking for the court to strike the request for submission. And I think she's mainly just afraid of the fact that her document, the opposition to my motion, might not get considered, because if the court decides she was late and it was not for a justifiable reason, the court can decide, hey, I'm not going to consider your opposition, and on that basis grant Alex's motion. So a little bit of a freak out and a whole lot of precautionary measures by my ex's attorney, but that's not to say that I still don't have to deal with it somehow. So I was actually curious in part 22 if I even bothered filing an opposition. And the reason I was curious is because I filed a reply on the same day that I got the opposition. I was like, well, it's late, but I'm just going to go ahead and reply to it. My concern, I suspect, was that the court would consider her opposition and just make a decision, and I wanted my reply to get considered as well. So my concern was the exact opposite of Catherine Burning's. My concern was that my document isn't going to be considered now because I've requested submission, and now there's an opposition I didn't expect was going to be there, and I'm supposed to get that second bite at the apple. That's the reply. That's the reply to opposition. So anyway, because of the fact that I did that, I wondered out loud in that video, I wonder if I filed an opposition to that motion to strike, and it turns out I did, and here we are right now. So let's go ahead and take a look at what I have filed. Here we have my opposition to that motion to strike. The first paragraph, just like all of the others, it simply identifies who I am, the fact that I'm representing myself. Well, actually, I didn't do that here. You're supposed to do that. Typically, you'll say something like, comes now petitioner, in this case, Alexander Falcone, appearing in proper person. I don't think I've started doing this yet, but eventually we're going to get to some of my custom filings, and I will always say, comes now, blah, 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 appearing in proper person. And that's just what you're supposed to do, let the court know that you are representing yourself. If you have an attorney, it's different. The attorney will prepare it for you, first of all, and they'll refer to themselves as, well, they'll refer to you as appearing through and by your counsel, and then they'll identify themselves. But in this particular document, I didn't do that, and I should have identified that I was representing myself. Just one thing for the viewers there. And again, I think I've already mentioned this, but I should have been doing that the whole time, all the way up to this point. I think there were probably 2 or 3 other custom papers that I prepared where I didn't do that. I identify the document that I am opposing, and it should have the date. So that's another thing that's missing there. It should say that I oppose my ex's motion to strike, and it should say the date that she had filed that motion, because sometimes there are multiple filings with the same title, and the court won't know specifically which one you're talking about. They can usually guess based on the timing of the filings, but you don't want to rely on guesswork. It's better to identify it by the specific date that it was filed. Anytime you are opposing or replying to an opposition, you want to reference what it is you are opposing or replying to. Scrolling down here, points and authorities. I'm splitting it out into the factual background, and let me scroll down a bit. Oh, there's just no legal analysis, so that's weird. Oh no, here it is, argument. Okay, I just didn't notice it there, which is good. And also, I'm noticing something different. The past few videos, I'm pretty sure I can at least say part 23 and part 21 of the My Docket series. There may be another video before that. I was detailing my facts by specifically addressing each allegation that my ex's attorney had made. In other words, I went paragraph by paragraph through my ex's allegations, and I responded to them in that fashion. And I mentioned in parts 23 and 21 of the My Docket series that that's not really the way you're supposed to oppose a motion, but I do know that that's how the self-help forms are built, and it's more akin to how you're supposed to respond to a pleading. For example, when you prepare an answer or a reply to counterclaim. And it looks like I've kind of gotten that clue here. It looks like I've been learning from my ex's attorney's custom filings, and now I'm no longer specifically referencing the paragraphs that I'm responding to. I'm just listing my factual background in a way that I can use those facts in my argument to actually address and oppose my ex's motion. So in this case, I am indicating when I filed, let's see here, filed the motion for order to show cause, the date that I personally served my ex's attorney, the date that I filed the request for submission, having waited 10 court days for her response, and that she filed on that day, the day that she was already late. It's going down into the argument. My ex's attorney admits to being personally served. It's important for me to highlight that for the court because that is going to control the number of time, the computation of time. The fact that it was personally served means that the 3-day extension does not apply. And here we go again. I'm again pointing out the fact that my ex's attorney admits that without those 3 extra days for mailing, that she filed it late. Let's see here. She claims to have received notification by e-filing. I made no attempt or intention to notify her by e-filing. I'm like, at this point in time, back in 2009, January, I don't even know what she's talking about. I didn't even know attorneys had this other system that they used. E-filing, which appears to be some sort of automated notification for attorneys, does not constitute service. Again, that's a great point to make. That is her weakest argument, and so I'm attacking that argument because it's her weakest. Let's see here, I personally served her. If e-filing was permitted to be recognized as service and upon simultaneous and automatic notification still grant the 3-day extension for NRCP 6E, it would render personal service to attorneys moot and not only distort the intention behind the rule, but should the e-filing become some automated service privilege to attorneys, constitute discrimination against pro se representation. All of that is very logical. I am saying it would frustrate the rule itself because it would just never apply. Anytime you get anything filed, you always get notified electronically. And number 2, it's unfair to people representing themselves because people representing themselves don't have access to that system. So attorneys would just always get those 3 extra days no matter what. Those are all great arguments. I wonder if I address the other ones here. To strike the petitioner's request for submission on the basis that the best efforts of the respondent to prevent punishing the respondent for her errors and failure to follow procedure would instead punish me, who followed all the standards and procedures and filed the motion for order to show cause in the best interest of my son. So I'm pointing out here that if the court is concerned so much about punishing my ex for her failure to follow procedure, inadvertently the court would end up punishing me, the one who actually did comply with procedure. Now, this still isn't a great opposition because there were two other arguments my ex's attorney made and I did not address either of those arguments. So that is bad. I should have addressed those arguments. The first one was that she should be given some leeway because of inexcusable neglect and because of the underlying policy that matters involving children, they call them domestic relations matters, not just children but families, should really strive to be brought to court on the merits, and the court should make a decision on the merits, not on technicality. And I'm not sure that I really could have beaten that. She was one day late, she rectified it, and she had proof that she tried to file it on time. So maybe I didn't, oppose that in this document because I just didn't have a good argument for it. Maybe I understood that, yeah, she was just a day late, and the inexcusable, what's it called, the excusable neglect provision applies. So that's a thing there. The other one, the third argument, was she was trying to ask for an extension of time after the fact. You can't do that. I could have opposed that. I could have found some case law. You're not supposed to file a motion to get more time after time has already expired. And the Supreme Court has talked about that. So all in all, I did, the best I could. I attacked the weakest argument. I brought up the fact that it was, quite frankly, a ridiculous argument. But I didn't deal with the other two arguments. And to be honest, a day late, I should have just said, hey, you know what? I just filed my reply. Just consider all three documents. That should have been my opposition to motion to strike. Don't strike my request for submission. Go ahead and consider her opposition, and here you go. Have my reply as well. Consider all three. That would have been a better opposition. But at this time, all those years back, I really didn't fully understand how all this worked. I probably got my ex's document and got I reacted and got defensive. I was like, this doesn't make any sense. This is illogical, and I'm going to need to explain to you why. Whereas nowadays, 2019 version of Alex, I'd be like, whatever. Go ahead and consider the op and the reply, please. And that would have been my, that would have been my argument. Don't strike it. Just consider everything. Next page is the affidavit. Talked about these before. Under the rules of the court, anytime you're making factual assertions in a motion, it must be supported by affidavit. I'm not even sure that they distinguish the necessity of I'm not sure if they distinguish whether or not the affidavit is required based on whether or not there are facts alleged. They might. I'm not going to go in and check right now. But if you filed a motion that was just based on pure law with no facts alleged at all, I don't imagine there would be really any point to the affidavit because you wouldn't be swearing under oath that anything was true. You would just be making legal arguments. Legal arguments are not testimony, nor are they evidence. Just want to make that clear to the viewers. Affirmation pursuant to, okay, this is the affirmation. I'm including it now in my custom filing, which means I'm not bothering to attach that self-help form version of the affirmation. This just lets the clerk know that I have reviewed the document and does not contain a social security number. The court will look at this and take my word for it. Motion opposition notice. This determines whether or not you have to pay a filing fee with the document that you're filing. In this particular case, I do not have to pay a filing fee. Scrolling down. Another affirmation. I did not need this. I don't know why it's here. And apparently I am indicating that this is just for the motion opposition notice. Yeah, that's just superfluous. Didn't need it. Move on to the next document. Affidavit of service. This is going to be for that opposition that I filed. Exactly. And again, served personally, which means I went down to that law office and personally handed a copy of this to a staff member at that law office, and that's what I'm indicating here. I think I've talked to my viewers about this, but there will come a point where I just include the certificate of service in the filing itself. I won't continue to file these separate documents. And here's the affirmation to the affidavit of service, which I've already talked about. Going into the aftermath, I filed both of these documents. However, neither required the payment of a filing fee. I also served them myself, so I didn't have to pay any service process fees. So that comes to $0 in costs. My ex didn't file either of those documents, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, I'm going to say, probably charged her, let's say, 15 minutes to review that opposition. It was really bare bones. It was barely a page. well, single spaced. In fact, I should probably mention right now, you shouldn't, at least not in Nevada, you shouldn't be single spacing your custom filings. I should have double spaced. That might have ended up being more, but still, it was pretty sparse. I really only addressed one of my ex attorney's 3 points, so I don't think it's totally out of bounds to assume that she probably just charged her for 15 minutes to review that. Of course, we've been staying on the conservative end. Some people sometimes message me about how attorneys inflate costs and fees, and that may be true, but for throughout the series, I've stayed on the conservative end. So let's stay with 15 minutes to review that opposition. Another 15 minutes to review the affidavit of service comes to a total of 30 minutes. Going with the rate of $250 an hour, we're going to go ahead and fix my excess attorney fees at $125. So if anyone has any questions, as for my previous videos, feel free to post something down in the comments below, and I will see you guys next time.